Plymouth Community Homes Limited.
Yes. Mr. Ward and Mr. Crozier, have the two of you had an opportunity just to discuss approximately how long you each think you need to make your submissions?
My Lord, no, we haven't actually had that conversation, with apologies.
Okay.
I would hope that I won't detain the court very much more than an hour and a half.
Right. Mr. Crozier?
I have a feeling I will be shorter than that, because I'm essentially supporting the Vice President's reasoning in the Upper Tribunal.
Right. Okay. Well, thank you. That's very helpful, and obviously you're both alive to the possibility we might just conceivably ask the odd question.
Yes. Yes, I'm very conscious. The President accused me of over-elaborating it in the court below, so I shall endeavour not to for you.
Right. All right, so Mr. Ward, you're for the appellant, Plymouth Community Homes Limited.
Yes, my Lord.
And they're the lessor in the...
Exactly so, yes.
Lease arrangements. Yes.
Strictly speaking, well, they are, of course, the successor to the local authority,
Right.
But continue, nevertheless, to be the relevant registered social landlord.
Yes. Well, we're familiar with the factual situation, and obviously with the judgment which is under appeal. And thank you both for your skeleton arguments. And Mr. Crozier's with perhaps a degree of self-effacement. It doesn't seem to appear in any bundle, but we have copies. So there we are.
There was a replacement bundle that my skeleton argument went into.
Okay.
I do apologise.
No, don't worry.
I'd been sent the updated version.
Right.
We've got it.
We've got it.
I'm grateful.
Yes. Yeah.
My Lord, I'm grateful. Well, that is the only change to the bundle. So if you have that document, then then all is present. If I might, with your lordship's leave, firstly correct something in my own skeleton argument, where at paragraph 32, I announce with great confidence that paragraph 16A1 doesn't have anything to do with discharging any obligations other than those which concern insurance. That is entirely wrong.
Yep.
So I do very quickly distance myself from that proposition. I will speak to section 16A1 when I set out briefly the statutory background to this matter.
Right. Thank you.
Well, we have permission to appeal this case on two grounds. We are concerned with two different units which are ostensibly similar, if not identical, in terms of their construction, the layout on the ground, and the freehold and leasehold arrangement relationship between the parties. One is a first floor in one block, the other is a ground floor. As to ground one of our appeal, we pursue that in respect of the first floor property, flat 96. I think this is clear, but I just want to be clear that that is the basis on which we set it up. And as to ground two, that is pursued in respect of the ground floor property at 146. They are, of course, in different blocks, but the principles apply discretely to each unit.
Yeah.
So we start then with the first floor property being at 96. This property has within its demise the roof. Lordships are familiar with the relevant provision with which we are concerned in the lease. We are concerned with a repair obligation which broadly represents the extent of the repair obligations on the part of the lessor to keep and maintain the exterior of the property, excluding the roof thereof. That forms part of the fourth schedule, which sets out the lessor's obligations. This lease was granted pursuant to the right to buy, and therefore we are concerned with section 139 of the Housing Act, which appears at page 3 in the authorities bundle.
When you say it's granted pursuant to the right to buy, that seems to have been common ground throughout. Is there a recital to that effect in the lease?
I anticipate so. My lord, if I could have just a moment to confirm that.
I see that clause 2 says that the lessor is acting pursuant to section 122 of the Housing Act 1985. I don't know what that section said.
Right, I shall double check.
Well, don't worry at the moment. Maybe come back to it.
Okay, yes, I'm sorry, my lord.
As I say, it doesn't ever seem to have been in dispute, but I just wondered where it came from.
It isn't something that that is in dispute between the parties. The remainder of actually section 122 is the exercise by a tenant of the right to buy.
So that is where it...
So that would appear to be the index recital, and the lease in other respects deals with the repayment of the discount that would have been applied if certain dispositions are made within certain periods of time.
Thank you.
Thank you, my lord. So with that end, if I might ask that we turn up page 3 in the authorities bundle. This is section 139, subsection 1. We are concerned with the second phrase within that initial provision. A grant of a lease so executed shall conform with parts 1 and 3 of that schedule. Reference to Schedule 6. I say that wording is important. Wording is that the document, the lease, the instrument, shall conform with the parts of that schedule. The relevant parts of that schedule, I believe it is common ground, appear then at page 10 in the authorities bundle. Paragraph 14.1 tells us that this is the relevant provisions where the dwelling house is a flat. Again, it is common ground, notwithstanding that this is entirely self-contained, but this is a flat. And we are told simply that there are implied covenants by the landlord to keep in repair the structure and the exterior of the dwelling house and of the building in which it is situated, including drains, gutters and external pipes, make good any defect affecting that structure. And then in part B, to keep in repair any other property over or in respect of which the tenant has rights by virtue of this schedule. Again, I do not think it anywhere seriously disputed that the roof, the replacement of which being the subject of this litigation, forms part of the structure and or the exterior. It is therefore common ground that 14.2a is engaged. Significantly, at subparagraph 4, and this does represent an evolution in the Housing Act. So this is a change in structure from the 1980 version of this. The County Court may, by order made with the consent of the parties, authorise the inclusion in the lease or in any agreement collateral to it provisions excluding or modifying the obligation of the landlord under the covenants implied by this paragraph if it appears to the court that it is reasonable to do so. So what we know so far is the lease granted pursuant to the right to buy must conform with that paragraph. That's the operative provision. That paragraph then says there are implied covenants, specifies them, and indicates that those covenants may be modified within the lease. It is perhaps slightly unfortunate that the legislative draftsman chose that approach, chose those words, indicated that something must conform, which suggests that it must be drafted in a prescribed way, must include certain provisions, and then goes on to talk about them as being implied. I say that is a catch-all provision. We then turn to page 11 in the authorities bundle and paragraph 16A, 16 capital A. This is a discrete set of provisions in my submission. The lease may require the tenant to bear a reasonable part of the costs incurred by the landlord in discharging or insuring against the obligations imposed by the repair covenant. The repair covenants stand alone. The requirement for a lease to conform with the repair covenants is separate from the ability of the parties to include within the lease provision that a reasonable part of the costs incurred by the landlord can be recovered from the lessee. I say, and again, that it is significant, subparagraph 4 there tells us that where in any case the obligations imposed by the covenants implied in paragraph 14, 2 and 3, so the repair obligations for our purposes, are modified in accordance with paragraph 14, 4, the power of the county court to authorise modification. The references in that paragraph, in this paragraph, forgive me, are to the obligations as so modified.
But in this particular case, there hasn't been any county court authorisation of any modification, has there?
Well, there has not been any county court authorisation of the modification, so to that end, there has not been effective modification. That's right.
So subparagraph 4 can't apply, can it?
No, it doesn't apply to the particular terms of this lease.
Right.
But what I say is significant about it is it forms part of the statutory regime. It forms part of a regime that specifically anticipates the possibility that there will be the sort of wording that we see in the impugned lease. The court will. And it speaks to this bright line distinction that is being drawn between express terms and implied terms. Now I say, before I make reference to the wider authorities, if it is the case that the implied repair obligations are entirely freestanding, entirely independent of any repair obligations that might be included in the lease expressly, then it must follow that the ability of the landlord to recover a reasonable part of costs in respect of those obligations is limited to those implied obligations and not any express obligations. Point being this: if we follow the Upper Tribunal's analysis, we accept that it is duplication or freestanding, then unless there is an express term in the lease that expressly says the costs that can be recovered are not in respect of the fourth schedule or repair obligations, but that expressly says are in respect of costs incurred in the discharge of implied covenants, then the landlord could not recover. I say that is an internal inconsistency, and it must deliver a fatal blow.
What is it inconsistent with?
It is inconsistent with the proposition that, which appeared to be accepted by the tribunal, that insofar as the express obligations extended to matters anticipated by the implied obligations, there could be recovery of those costs. And I say it cannot be both. Either it is the case that the lease is valid and effective, providing it conforms with, that is, it includes those matters anticipated by paragraph 14.2, and costs can be recovered pursuant to 16A, or not. The effect of the Upper Tribunal's decision.
I'm so sorry.
Don't worry.
I'm so sorry.
I did it yesterday.
Yours is more melodious than my lord's was yesterday.
My lord, if the analysis in the Upper Tribunal is correct, then it cannot be both. These freestanding obligations cannot exist alongside the express obligations. I say that is not the purpose of the statutory scheme. The purpose of the statutory scheme is to say, in the grant of a lease, pursuant to the right to buy, certainly at the time, the following matters need to be dealt with and need to be dealt with in this way. If it is right that the express obligations sit alongside the implied obligations and there is duplication, then it seems to me, unless we follow the letter of paragraph 16A and the lease expressly says you can recover the cost of the implied obligations, we find ourselves in a slightly absurd position where we've got a lease that sets out repair obligations which are perfectly consistent with that which the legislation requires, but because it does so expressly and then simply requires that those express repair obligations are supported by contribution from the tenant and goes no further than that, there's no ability to recover, because the only ability to recover is in respect of those matters arising out of the implied covenant. And what I say is that cannot be what the tribunal intended, and that certainly cannot be what the legislation intends or how it operates.
So does your argument really come to this, Mr. Ward, that the the obligation to conform with the schedule can be satisfied either by express terms of the lease which are consistent with what the schedule provides, or, if there are no such express terms, by the statutory implication of whatever's needed to plug the gap?
My lord, yes, precisely.
Right.
If you had a lease which precisely tracked the implied covenants in 14.2, which said the landlord covenants to keep and repair the structure and exterior of the dwelling house and the building, etc., and then said the tenant shall pay 50% of the cost of complying with that obligation, it would be a very ambitious argument to say that the landlord couldn't recover, because it didn't say the lease that the tenant has to bear a reasonable part of the costs incurred by the landlord in discharging against the implied obligations. That's your point.
My lord, that is precisely my point. Yes. Yes.
But if you had that sort of lease, speaking for myself, I think the court would find it very easy to regard the express obligation in the lease as simply tracking the implied obligation, and the provision in the lease which required the tenant to pay 50% of the cost of it as authorised by 16A1. The fact you've written out what the statute provides can't really have been intended to stop the tenant from being liable on the service charges. I mean, that's not our case. I mean, the problem is that's not our case. Our case is the express obligation excludes the roof.
Well,
and so the question whether the landlord is liable to repair the roof can't be determined by looking at the lease. It can only be determined by looking at 14.2, and I think you accept the landlord is liable under 14.2 by a statutorily implied covenant to repair the roof.
my lord, yeah. Forgive me, sorry.
So why is the Upper Tribunal wrong to say that on this lease, that implied covenant to repair the roof sits alongside the express covenant, which does not include the roof? It has to be a separate obligation, because the express covenant quite plainly doesn't include the roof, but the implied obligation does. And if that's right, then the only question is, does the service charge provision cover the cost of repairing the roof? That's the question. Well, it doesn't do so expressly, because expressly it says the fourth schedule, and this isn't a fourth schedule obligation. So how do you get the obligation to contribute to the service charge? That's what I'm having difficulty with.
My lord, I'm very grateful for the clarity of the court's mind on this. My lord, that is exactly my point. My point is, and there is authority in Great Arthur, that the statute can be tracked, and where the statute is tracked, we treat it as conforming with.
Yes.
And if that is correct, then it is not enough to look at 14.2 in a vacuum. We then need to look at 14.4. And 14.4 expressly admits the possibility that the county court may, by order with the consent of the parties, authorise the inclusion in the lease or an agreement collateral to it. So something within the lease, and that is what I say is the case here, that seeks to modify or exclude the obligations of the landlord.
But that hasn't happened.
The county court has not authorised it, no, so far as we can tell, my lord. That's quite right.
So what? The fact that it
Well-
could have done, so what?
Well, that, my lord, is precisely the point.
Well, what's the answer?
The answer that we give is that means the wording is simply inchoate.
Inchoate.
It is an attempt to modify, which is capable still of being brought before the county court by the parties to modify the covenant. This is not a case where the lease sets out repairing obligations which do not quite go far enough. This is not a case where we're asking whether or not the wording can be considered to include the roof. This is a case where there is wording which expressly attempts to modify, limit or exclude something from a repairing obligation that would otherwise be part of 14.2. That attempt is specifically anticipated by 14.4. The lease is not silent, and that is the point. There is nothing ineffective or invalid about that attempt. It simply remains incomplete because it has not been brought before the county court.
Forgive me, this is probably far too simplistic an approach, but if it's incomplete, how can you rely on it?
My lord, I don't rely on it.
Your case is you should read the covenant and the fourth the schedule
Yeah.
as excluding the words, excluding the roof.
My lord, I'm concerned about overcomplicating the response to that because the effect of what I'm going to say is to answer your question in the affirmative. But what I say is we don't need to strike through it on the basis that it's invalid. We simply look at it and we recognise that the condition precedent that must attach to it, which is set out in the statute, an attempt within the lease to modify or exclude, must be subject to the approval of the county court. That hasn't happened, and so those words, pending that happening, are not effective. They're not operative. That does not mean they are void or incapable of having effect. It means that they cannot bite unless and until the county court has so authorised. So I say the wording does track the statute faithfully. And I say that 16A(4) goes on to further anticipate that. So the statutory scheme is designed to allow for precisely this possibility, that the modification is incomplete cannot be a source of criticism or failure or default, because it does not say if you attempt to modify you must go and get a county court declaration or the words will be given their meaning with unintended consequences. It simply says if you want your modification to work, you need an order from the county court. It's entirely open to the parties, I say, and I repeat, to go to the county court and seek such a declaration. And my lords, I say it's not difficult to imagine why they might. In this particular case, we are concerned with the first floor flat in a building of which there is a ground floor flat and a first floor flat, and the roof above it, which is demised. It may very well be that the leaseholder of that flat would seek to convert the attic to install dormer windows. So it's perfectly commercially sensible. my lord, I say it's the only analysis which is faithful to the wording in the lease, which properly tracks the statute, which doesn't operate so as to put some kind of a gloss and say, well, you track the statute up until this point, but you stop tracking the statute at that point. Because in my submission, my lords, it does track the statute. It's an attempt in the lease to exclude a matter which would otherwise be in 14.2.
The persons who can apply to the county court are the parties to the lease. Is that right?
The statute, my lord, says, by order made with the consent of the parties. What I say is, by privity of estate, the parties become the landlord and tenant from time to time.
Yes, I understand that, but it's the landlord and tenant from time to time. It's not the prospective tenant. It just strikes me that the effect of your argument is that someone who's interested in occupying one of these flats but would like to be confident of the extent of any liability to contribute has to enter into the lease first, then apply to the county court with his fingers crossed that the result will be as he would wish.
My lord, I think that has to be right. If they are not a party to the lease by one way or another, then I don't see that they have standing. Transactionally, no doubt, a party could seek to agree such matters with an outgoing tenant who would take necessary steps, and all of these things could be protected contractually.
So it requires parties to sign a lease on the basis, if your argument is correct, that everyone understands that some of these terms may or may not apply. Which, speaking for myself, just seems a rather odd way to go about things.
Well, my lord, the presumption is the parties can be assumed, or at least as a starting point, it is assumed that parties would not enter into a document that is invalid or ineffective. But my point is...
You're saying it is ineffective, because it's incoherent.
Well, Lord, I'm saying it's incoherent as opposed to ineffective. So it is capable of perfection.
But the landlord's obligation is to maintain the structure and exterior of the demised premises and the building in which they're situated. So let's suppose this is a bigger building, and instead of 2 flats on the upper floor and 2 flats on the lower floor, let's say it's 20 flats long, 20 on the upper floor, 20 on the lower floor. Somebody who wants to have a lease of one of the upper flats in the middle is probably going to want to know, isn't he? Well, what's my position going to be if the whole building needs to be re-roofed? Particularly if it needs to be re-roofed because the indolent tenants at numbers 4 and 6 have allowed the whole thing to fall into disrepair. And I'm just speaking entirely for myself. I'm just struggling to understand the effect of your submissions on the parties to the lease, because you have to sign up to it before you can do anything about modifying it. And if your desired modification isn't achieved, you're stuck with a lease, which may in fact be on very onerous terms.
My lord, that might very well be right. It's not outside the realms of possibility that if my analysis is correct, there are going to be parties who could be negatively affected rather than positively affected. But if we explore some of that, the obligation is nevertheless on the landlord to undertake the works, because it is an implied term, it's an implied obligation. It is not, as I understand it, the Upper Tribunal's analysis of this, that if I am right, the roof would never be fixed. This is a problem for the freeholder in terms of whether or not they can recover the associated costs. So that is where the burden lies, if there is. It seems to me that any other leaseholder in the block or anybody coming to one of the leases in the block is entitled to rely on that. The repair work will be done, and they will be required to contribute whatever they are required to contribute under the terms of their lease. And if their lease is on comparable terms, then this is precisely why this question needs answer. My lords,
I think I'm being very slow here. No one disputes that as a consequence of paragraph 14.1, 14.2, the landlord was under responsibility to repair the roof.
quite
Full stop, end of story, everyone agrees.
yes.
Then one comes to the terms of the lease, and what we're concerned about is not whether the landlord has a responsibility, because everybody agrees that the landlord has a responsibility, but whether or not the landlord can then pass on the cost to the tenant.
My lords, yes, that becomes the consequence of the question. Yes.
Right. So paragraph, if you want to know what the lessee has to pay for, you look at paragraph 12.
Yes.
And that does it by reference to the terms of the fourth schedule, excluding paragraph 4.
Yes, my lord.
And the effect of that, as it seems to me, is that if you're simply looking at payment obligations, 4 has gone, 5 remains, and 5 excludes an obligation to pay for the roof. Doesn't affect your obligation to repair the roof, but it affects their obligation to pay for repairs. What's wrong with that?
Well, my lord, what I say about that is the fourth schedule sets out covenants on the part of the lessor. That sets out the obligations that the lessor has, the landlord has. The payment
but everyone's
obligation-
agreed that paragraphs 4 and 5 of the fourth schedule do not mean that you're under no obligation to repair the roof. Correct?
My lord, that's correct.
Right.
But
So
that,
they're only of interest in relation to the question who pays.
my lord, that might be right, but the question is why we are still under an obligation to repair the roof, notwithstanding the wording in there
Because you've agreed to.
that says excluding the roof thereof.
Because you've agreed to.
Well, have we or haven't we? Because we've included words that are anticipated by paragraph 4, subparagraph 4 of paragraph 4.
But that's why, in a very simple and simplistic and deliberately, probably obtuse way, I started by saying everybody agrees that you're under a responsibility to repair the roof.
Yes.
No matter how, I lose interest in the interstices of this agreement, but that's common ground. You had the responsibility to do the roof. Then it's a completely different question, which is who pays. And the only, on the part of the argument that you're developing at the moment, as it seems to me, the response to your argument is it's all very neat and fine and dandy and clever and learned, but the obligation on the lessee is determined by paragraph 12, which then cross-refers to paragraphs 4 and 5 of the fourth schedule.
My lord, yes.
Well, I just, at the moment, and it's probably me, but I just don't understand what's wrong with that.
My lord, there is nothing wrong with that, but for what the effect of paragraph 5 is, what paragraph 5 actually says. Paragraph 5 is a repairing obligation. If we interpret this lease, paragraph 5 is intended to set out what the lessor is required to do.
And paragraph 12 of the third schedule, together with paragraph 5, determines what the lessee's got to pay for.
Yes, my lord, yes.
And it excludes the roof.
Well, it excludes the roof if those words are effective. If those words are not effective, then it cannot be the case that it is excluded from the payment obligation. That is my point, my lord. It's an entirely separate. The two things work together, but they are separate. They are discrete. So if we were to not give effect to part of the lessor's repair obligation, then the lessee's obligation to pay would similarly fall away. And my lord, that is what I say is the significance of 16A4. Because 16A4, paragraph 16A4, forgive me, says that if there has been modification, then the payment obligations are modified accordingly. So the statute anticipates that it is possible to modify the repair obligations. It deals with repair and payment obligations separately, and it says if you modify the repair obligations, then your payment obligations are modified accordingly.
So how does it say that?
Paragraph 16A4, my lord, page 11 in the authorities bundle, where in any case the obligations imposed by the covenants implied by virtue of paragraph 14.2 or 3 are modified in accordance with 14.4. The references in this paragraph are to the obligations as so modified.
Yes.
The references in this paragraph are to the obligation to pay towards those.
So where do you get that bit from? Because this paragraph is concerned with the obligations imposed by 14.2 or 3, which are liabilities of the landlord.
Yes, my lord, yes.
And the final words of the paragraph surely mean the references in this paragraph are to the obligations under 14.2 or 3 as so modified.
Yes,
Not any other provision.
No, but it is to deal with the 16A1, which is the lease requiring the tenant to bear a reasonable part of the costs incurred by the landlord in discharging those obligations. It means...
Well, but 16A1 is permissive.
Yes. Yes, it is permissive, my lord. That's absolutely right. But what it says is that it is permissible for the lease to require that a reasonable part of the cost is paid. But if the obligations are modified, then the costs of those are modified accordingly. It follows the modification. So the obligation to pay is modified by... the obligation to pay, if and to the extent it is set out in the lease, is modified by any modification to the repair obligations.
You could have said, consistently with the statute, the landlord shall keep the structure and exterior in repair, including the roof. The lessee shall pay 1/2 of the cost of the landlord in carrying out those repairs, but not the roof. You could have said that.
My lord, precisely. And that is not what is said. The exclusion is in the repair obligation, not in the payment obligation. So I say, in order for the payment obligation to follow the repair obligation, there must have been a modification, because the lease doesn't exclude it from the payment obligation.
But that's not right, because paragraph 12 is a payment obligation. And it's paragraph 12 which excludes clause 4. Paragraph 12 is a payment obligation.
Yes, my lord.
It says you look at the provisions of the fourth schedule,
Yes.
but exclude clause 4.
Yes,
That's
my lord.
pure payment.
Yes, my lord, yes. But clause 4 doesn't have anything to do with the repair obligation or the roof.
Okay. Well, and I thought you were saying that the mechanism that's being adopted was all to do with by adjusting the repairing obligation, not the payment obligation. But maybe I misunderstood that too.
My Lord, I took and agreed my Lord's point that if you wanted to exclude, if the draftsman wanted to exclude the obligation to pay for the repair of the roof, the appropriate place to expressly exclude that would have been in the payment obligation.
That wasn't my point. That's your point.
It was it was my Lord's point, and I agreed with my Lord, and that's the answer to your point, which is that the repair obligation stands independently. Well, it might be fair to say that the appellant's case is set up on, or at least admits questions about, the interpretation of both the statute and the lease. So in terms of the principles with which we are concerned with how we are to construe this lease and these particular provisions. And that is so because if I am right, then the wording that is included in the repair obligation, which seeks to exclude the roof, is to be interpreted as an attempt at modifying the repair covenant. The question in terms of the statute is then the effect of that. At a headline level, there is no dispute that the freeholder is responsible for repairing the roof. The question is what the statute does to that wording in the lease. The question is whether it remains and is considered effective, whether it remains and is of no effect until the remainder of the statutory test is met, i.e. the authority of the county court, or whether it is to be struck through I say it doesn't need to be struck through. So we don't need to meet the threshold that does that. The terms of the contract should be read as a whole. This clause provides a comprehensive scheme of maintenance.
So which clause?
The, forgive me, paragraph 5 in the fourth schedule. It sets out the lessor's maintenance and repair obligations. It is right to say that it would be assumed that the parties intended something that was lawful and capable of having legal effect. And if that is so, the aim of this part of the contract must surely have been to satisfy the statutory requirement in section 139. My Lords, the authority for the proposition that the object or the aim of the contract is relatively trite, but I draw it in particular from Brennan Simmons, page 88 in the authority bundle.
Lord Wilberforce.
My Lord, yes.
Lord Wilberforce is dealing with a question of construction, I think,
Yeah.
in that case. What profits meant,
Yeah.
something. What is the question of construction of the lease that you are inviting us to apply this principle to?
Whether or not the words excluding the roof in the repair obligation
Yes.
were an attempt to exclude a repair obligation as anticipated by paragraph 14.4 to Schedule 6 of the Housing Act.
And if they were, you say they're ineffective, so you effectively read the lease as if they weren't there. Is that?
You read the lease as if, absent the authority of the county court, they are of no effect. But they are not invalid because it is legitimate for the county court to step in. And that is not a rectification, that is not the correction of an error, that is simply a step that needs to be taken, which the parties may or may not choose to take.
Yes, but as matters stand, they haven't taken that step.
Indeed.
So you, as I understand it, your case is this was an attempt at a modification which has not yet succeeded.
Quite so.
Therefore, you read, for present purposes,
Yes.
the clause in the fourth schedule, paragraph 5, as if it didn't have those words in it.
Yes, my lord.
Thank you.
But you do not need to take the step of striking them through because it is still open to the parties to make an application, which is not by way of rectification. It's not a mistake. It might well have been, frankly, we cannot know. The point is that is not the legal analysis that I offer.
Yeah. And that's effectively the submission that the First-Tier Tribunal accepted.
My lord, yes.
Thank you.
My lords, when we consider if that is the appropriate interpretation of those words within the lease, in my submission we should have in mind the dicta in Arnold and Britain, and in particular at paragraph 15, which appears on page 104 of the authorities bundle.
It's Lord Newberger.
Yes. We are towards the end of that paragraph told that the meaning be ascribed to the words in the lease, and this matter did of course concern service charge provisions. The natural and ordinary meaning of the clause. Well, my lord, it seems to me that excluding the roof thereof is an attempt to exclude the roof from the maintenance obligation. We're to consider any other relevant provisions of the lease. This is the part of the lease that deals with the lessor's repair obligations. it is set up discretely from payment obligations and other such obligations. The overall purpose of the clause and the lease. Well, my lords, I say the purpose of the clause is to set out the repair obligations on the part of the landlord, the lessor, in a way that is compliant with the statute. Must have been the purpose that it was lawful and compliant. It's expressed to be pursuant to the right to buy. The purpose of the lease is to grant an estate in time to the tenant and to appropriately distribute responsibilities. The facts and the circumstances known or assumed to be known do of course include and extend to the relevant legal regime. It would have been known to the parties, or can be assumed to have been known to the parties, that the attempt to exclude the roof from the maintenance and repair obligations could only be perfected with the authority of the court. And finally, commercial common sense. There is authority for the proposition that we do not need an absurdity to be created before commercial common sense is to be considered. Simply, if there are two competing interpretations, possible interpretations, then that which is the more commercially sensible can be preferred.
Is that Sharpbrook? Or is it Rainy Sky?
I believe it is Rainy Sky.
It's Rainy Sky and also Excalibur. I don't think it's Sharpbrook. Sharpbrook was a case of a drafting mistake, which is a rather different thing from choosing between two competing interpretations.
I'm grateful to your lordships. It is indeed Rainy Sky that I have relied on. I can take you to the relevant part of the case if it would assist, but in particular paragraphs 20, 21, 30 and 43. Which appear at pages 180 and 182 in the authorities bundle.
These submissions are all about how you construe contracts, but the problem we're faced with here is not really one of construction. It's the words themselves are perfectly clear on the page. The landlord's liable to repair the structure and exterior, but not liable to repair the roof. So we're not being asked to choose between two competing interpretations. Really, your submission comes down to, because that is a modification of the statutory regime, it is ineffective unless and until authorised by the county court. Therefore, you now have to read the obligation in paragraph 5 as if those words were of no effect, and hence the payment obligation covers the obligation in paragraph 5 as if those words weren't there. That's your case. Now, that's not really a question of construction, but in the sense that Arnold and Britton and Rainy Sky and Sharpbrook are dealing with, which is where you're choosing with what different interpretations of what the words mean, because we can see what the words mean, and there's no ambiguity about them. What we're really dealing with is what is the effect of an attempt that is ineffective of modifying the statutory regime. I don't really regard that as a question of construction at all, but That's the way I see it at the moment.
My Lord, I'm grateful. What I say is it is capable of being a matter of construction of the contract, because we are concerned with the effect. If we have tracked the statute, then we are concerned with the effect of the payment obligation. So absolutely, if the effect of the statute is to strike through those words, then there is no question of construction of the repair obligation. And by extension, there then cannot be any question about the construction of the payment obligation. But if that is not the effect of the statute, then the question of construction must arise.
What question of construction?
Sorry, forgive me. The question, my Lord, of construction of the payment obligation under the contract, because what we say is, well, if the effect of the statutory regime is simply to leave those words intact,
Yeah.
then what happens when we look at the payment obligation on the part of the lessee? Do we consider that those words, whilst being of no effect in the repair obligation, actually are effective in the payment obligation? Now I say, whether we analyse the statute or analyse the statute and then consider the impact of that in this case, there cannot be escape of the payment obligation. But my Lord, we still have to deal with, because if I am correct and those words are not read, the question that then presents is, what do we do with the payment obligation?
Yeah. Thank you.
I mean, my Lords, candidly, on ground one, I cannot see that I can go very much further than that. That is to say, there is no requirement to strike through. There is nothing in the statute that says you need to strike through words. There isn't a problem here. There's not a mistake. A condition precedent is set, and the statute also provides that payment obligations, if they exist, attached to repair obligations as modified if they are modified. So the effect of that has to be, if there is a repair obligation and there is an attempt to modify it, that can only happen with the authority of the county court. If there is a payment obligation in respect of the repair obligation, that follows the obligation. So if the obligation is modified, so too is payment obligation. We are still slightly concerned with construction and interpretation because we have this slight tension, your Lordship's will, between the operative provisions of section 139, that the lease must conform with paragraph 14, and then paragraph 14 saying there will be implied terms. It being well settled that if the express terms track the implied terms, then we do not have two separate sets.
Do you say that's in Great Arthur?
As to tracking, my Lord, yes. Yeah.
Where is that?
That is, I believe, the beginning of the analysis is paragraph 36 in Great Arthur.
Paragraph which?
I believe paragraph 36, my lord, which appears on page 26. Yes, the this is very much obiter, I accept, but it informs the approach of the court in that case. The definition of specified repairs in the lease to a large extent follows the statutory provisions. Part 1 tracks paragraph 16, Part 2 tracks paragraph 17.
Well, it makes sense. If you simply wrote out in the lease what paragraph 14 requires, it would be very surprising if that wasn't effective.
Absolutely.
But the effect of paragraph 14 must be that if you don't write out what's in paragraph 14, then it's still effective.
My lord, I completely agree. The distinction in this case, of course, is that we've written out what's in paragraph 14 and then we have expressly excluded something that's in paragraph 14, and that attempt at expressly excluding something is expressly anticipated by paragraph 14(4) in the statutory regime.
Yes.
My lords, unless I can assist further on ground 1, I'm content to move to.
And ground 1 only applies to 96, not to 146. That's because in 146 there's an express provision saying the landlord will keep the reserved property,
Yes.
which is the upper flat, which includes the roof,
Yes.
in repair, and the payment obligation expressly excludes contributions towards that.
Yes. Yes,
So,
my lord.
yeah.
Yes. Exactly so.
Thank you.
So on to ground 2 then.
And this only applies to 146.
My lord, yes.
And that is because the Upper Tribunal's right that, so far as 96 is concerned, you can hardly be said to have a right of support from a bit of property you own yourself. Is that?
My lord, yes, I think there is much to be said for that.
Yeah.
We pursue it in for practical purposes.
I see.
Yes. Rather than reasons of principle, but yes, I don't challenge that point.
Thank you very much.
But for, of course, the observation that a lessee can still have a right of support from a property belonging to the landlord. But I don't see that an easement could be granted out of something that you would demise. The two would go together. So,
Yeah, there does seem to be a logical difficulty with it.
indeed so.
Yes.
Well, I can put this quite simply, I hope, and I can't really say very much beyond that which is contained within my skeleton argument. But there are elements of the Upper Tribunal's reasoning that I say are wrong, candidly. In that the Upper Tribunal has looked at the rights reserved in the first schedule to the relevant lease, which starts at page 31 in the supplementary bundle.
Yep.
Number 1 grants a right of way. Number 2, passage and running of media. Number 3, I say, crucially, the rights of way, support and other easements and or quasi-easements, rights and benefits of a similar nature now enjoyed or intended to be enjoyed by the demised premises. As an aside, that is also a matter which is required to be included by the Housing Act in right to buy leases.
Which paragraph of the Housing Act provides that?
1, paragraph 1, there can be no exclusion or restriction of section 62. And paragraph 2, conveyance, this is to Schedule 6, forgive me, my lords.
Yep.
Conveyance or the grant shall have the effect stated as regards rights of support for a building or part of a building, access of light, passage of media.
It doesn't expressly deal with rights of shelter, does it?
It does not expressly use the word shelter, my lord, no. It does go on to say to grant with the dwelling house, which again includes a flat, all such easements and rights over other property so far as the landlord is capable of granting them, as are necessary to secure to the tenant, as nearly as may be, the same rights as at the relevant time were available to him.
Forgive me, I'm behind. Where are you?
Forgive me, my lord, that is paragraph 2, subparagraph 2 of Schedule 6 to the 1985 Housing Act.
Well, that just begs the question as to whether you would have a right of shelter if you had a secure tenancy of the lower flat. Would you?
I think you must have, my lord. Yes, you would be entitled to expect your landlord, other than by way of Section 11 repair obligation, you would be entitled to have the benefit of shelter from the roof.
Well, there is a difference between a right of shelter, which is a quasi-easement, and a right to have someone else repair the roof. Because rights of support and rights of shelter enable you to prevent somebody removing the support or the shelter. So if the landlord was proposing to take the roof off, you could get an injunction to stop it. It also, I think, if you're the dominant tenement, gives you a right to do repairs yourself. You can go on to the servient tenement and repair the roof yourself, but it doesn't in itself impose any obligation on the servient owner to do any work. So they are different. I just wonder whether you do have a right of, I mean, maybe it doesn't matter, but I wonder whether you do have a right of shelter if you've got an express repairing covenant, which is a rather more useful obligation than simply a right to do repairs yourself. But anyway, don't let me detain you, because the judge assumed that the relevant paragraph 3, which refers to other easements, quasi-easements, rights and benefits of a similar nature, was sufficiently wide to include a right of shelter.
My lord, quite so, and I don't say that the existence of the right to enjoy it in the species of an easement imposes the positive obligation. That isn't my argument, but my argument is that there is a positive obligation to, separately within this lease, to provide the rights within this schedule. And it is on that basis that there is an ability to recover the costs. My lords, so continuing, then there is a right at paragraph 4 of the first schedule to connect into services, I take to be service media, and the right to repair and maintain, etc. There is then at paragraph 6 a right of way, which is subject to contribution to payment, and then at 7, rights of entry. Forgive me, I'm looking for the obligation to pay.
It's the same paragraph 12 of the third schedule. It's the final words. And in enabling the lessee to enjoy the rights contained in the first schedule.
Quite so. I'm grateful, my lord. And my lord, the Upper Tribunal was more concerned in paragraphs 61 through 63 of the judgment, which appears on page 65 in the court bundle. Although I rather fear it might be a different number if you have the version that hadn't included Mr. Crozier's skeleton argument.
Which paragraph numbers?
Paragraphs 61, 62 and 63, my lord, which is page 13 of the judgment, wherever
Yes.
it might appear. And in particular at paragraph 62, the final sentence, the Upper Tribunal concludes that it would have been likely that the additional obligation to contribute to the costs of enabling the lessee to enjoy the first schedule rights was in fact a reference to the contribution obligation set out in paragraph 6 of the first schedule. My lords, I say simply, well, that just isn't what it says. Even were that to be something that is, with hindsight, unwise, that is nevertheless a very plain meaning that is expressly set out. And if that were held up against the statutory regime, right to buy leases, there is nothing within it that offends it.
The main, as I read it, ground on which the Upper Tribunal decided against you on this point was that the payment obligation expressly excludes the cost of repairing the reserved premises and hence the roof. And it would be very bizarre for the lease to have, by those words at the end of paragraph 12, included the cost of repairing the roof when it's been excluded by the earlier words, which are more specific. I think that's how I read paragraph 61 of the judgment. What's wrong with that analysis?
My lord, what is wrong with that analysis is simply that it isn't what the lease says. It's a perfectly reasonable and sensible assessment, but it isn't what the lease says. It is to import a meaning to the words. It is to rewrite rather than interpret. There is no reason to strike through or rewrite either of these provisions on the analysis that I offer. It might be said, well, it imports an obligation to pay only once. It is not as though there is a duplication of obligation.
Okay, let me put another argument to you. The first schedule, the relevant paragraph, confers rights in the nature of easements or quasi-easements.
Yes,
rights of support, etc. And the relevant one here is a right of shelter. Now, as I put to you earlier, a right of shelter, like other easements, doesn't impose any obligation on the servient tenement, here the landlord, to do anything. It imposes negative obligations, not to interfere with the rights, so you can't knock the roof down. But it doesn't impose any repairing obligations on the landlord. The words at the end of paragraph 12 of third schedule, well, the lessee has to contribute to the landlord's costs of enabling the lessee to enjoy those rights. The landlord doesn't have to spend any money to enable the tenant to enjoy a right of shelter from the roof, because it's not a right to require the landlord to mend the roof. It's a right that enables the tenant to mend the roof and to require the landlord not to do anything positive to interfere with that right. So why is the cost of repairs, which is prima facie referable not to the right of shelter but to the repairing obligation imposed by paragraph 14, why is that within the words the cost to the lessor of enabling the lessee to enjoy the right of shelter? How does repairing the roof enable the lessee to enjoy the right of shelter?
Why not? Because it enables the lessee to continue enjoying a roof providing shelter.
Yes, but that's not the nature of the right of shelter. That's what I was putting to you. That this is a negative. It's a negative obligation.
It's a negative obligation, my lord. Yes, it is not an exercise whereby the tenant, other things being equal, could compel the landlord under that obligation. I accept, but that does not mean to say that should the landlord nevertheless enable shelter, he's not entitled to recover the costs.
I see. Okay, thank you.
My lords, unless I can assist further, that is the basis on which I set up ground two.
Thank you very much indeed.
Thank you very much.
Mr. Crozier.
My lords, subject to what your lordships throw at me, I'm going to be very brief, I suspect, because your lordships have made, I think, every point that I, at some point during the course of the Learned Friends, of course, I don't take that as an indication of the court's decision, but your lordships have raised all the points that I'm about to make.
It's our duty to test the argument. It doesn't mean that we don't accept it.
No, indeed, I entirely take that on board, my lord. But this is about the starting point in my respectful submission is that this is about a payment obligation. It's not about repair obligations. And I've phrased it in that way, and in phrasing it in that way, I have potentially fallen into the trap the learned friend has set for himself, I suspect, having heard his arguments, as well as the rest of it, as well as the rest of us, because this is also not a case about repairing obligations as such, because one can't group, in my respectful submission, obligations that are repairing obligations under the lease with obligations that are implied obligations under the statute. And where my learned friend's starting point is section 139, which says the lease shall conform. In my respectful submission, he starts going wrong at that point, because what one has is a lease with express terms, and one has a statute that implies terms. Every point at which the obligations are referred to then in Schedule 6 talk about the obligations implied by this schedule. So it's not talking about repairing obligations. The fundamental error, in my respectful submission, that the learned friend is falling into is aggregating, because this is one set of because there is one set of repairing obligations under the lease and one set under the statute, that they are the same creatures as matters of law. In my respectful submission, they're not. One knows, I've used the example in my skeleton argument of sale of goods. One knows one can have exactly coextensive express and implied terms, and it's no different here. Equally, one can have disjunctive express terms and implied terms that are not necessarily exactly the same, nor is there any need to be. In my respectful submission, that where the learned friend points to section 139 and says the lease must comply with the statute, the lease in this case does, because it has the implied terms. Now, my learned friend would have a point if it had said at some point, excluding the roof, whether under the, or if it had sought to exclude the implied repairing obligations. But there's nothing in the lease that does that. My learned friend saying, well, there are some repairing obligations that are expressly made, that are limited, and now all it doesn't so much exclude, it limits the ambit of the express obligations. That doesn't mean the implied obligations don't apply. And, my lord, as a sort of thought exercise, I imagine myself following the learned friend's advice and going to the county court to make an application to disapply under 16A4. And I'm afraid I got as far as this. County court judge, who's interventionist, says to me, well, Mr. Crozier, it says the obligations under this schedule. The express obligations aren't under this schedule, are they? Well, Your Honour, no. And then somehow one would have to develop the learned friend's argument. Well, the spirit of it is to modify the repairing obligations, in air inverted commas, globally. But that flies in the face of what the contract says. And I'm grateful to my learned friend for drawing attention to our Northern Britain, because it says in terms. The contract, where the wording is clear, has the meaning that is clear. I accept entirely the learned friend's point that when interpreting this, one presumes that the parties will have had in mind the statute. But there's nothing that's inconsistent with the statute, because even paragraph, as my Lord Holroyde said, paragraph 16A1 is permissive. It says the parties may make provision. It doesn't require that everything that's covered by the implied covenants is or is not recoverable as a service charge. So that's where, in my respectful submission, at the very heart of my learned friend's submission, at the very start of it, there is a fundamental error, which is that somehow one has to read a contract which makes a lease which does, there's a recital about section 122 and the right to buy in both the leases, but plainly has the statute in mind, expressly provides that certain obligations are expressly there. I interpolate there, it could have equally been in compliance with the statute had it made no reference to those repairing obligations, because they would have been implied. The lease would still have complied with the statute. The lease complies with the statute because they do apply, and also, not only are they implied, there are some that are expressly provided for. It's when one comes to working out what needs to be charged, or for what the landlord is permitted to charge, that one runs into the clear wording which excludes the roof from the express repair covenant and leaves it, I put in parentheses here, leaves it to the implied covenants to do that bit of heavy lifting. The result of that is that the roof is excluded
From the payment obligation.
From the payment obligation, exactly so. Your Lordship, I think, rather queried whether your Lordship was being obtuse. Your Lordship is not in my...
That won't get you anywhere, Mr. Crozier.
no, but it's exactly that point. And in my respectful submission, what my learned friend is endeavouring to do is to find some construct, as it were, a drafting infelicity, where none exists.
Not really a drafting infelicity. His case is you can't modify the implied terms except by going to the county court.
Yes.
These words, excluding the roof in paragraph 5 of the 4th schedule, are an attempt to modify the implied terms. You didn't go to the county court, so they're ineffective. So you effectively read paragraph 5 as if they're not there. And if you read paragraph 5 as if they're not there, then the payment obligation catches what's in paragraph 5 without those words. That's his case. It's a very
simple case, yes.
And it was accepted by the FTT, but it wasn't accepted by the UT.
No.
Well, that's what we have to decide.
That's what you have to decide, exactly.
I don't think it's really a case of construction or drafting infelicity at all. There's no ambiguity about the words. The question is, what's the effect of trying to...
And my lords, I'm not going to get my argument on ground one any better than that. It is quite simply this, that if somehow you read the statute as referring to repair obligations globally, rather than you might start to get the learned friend's argument off the ground, but that's not what the statute says. It says the obligations implied by this statute. And so it's not an attempt to modify. One comes back to my imagined county court application, where the court would simply have to say we have no jurisdiction. It only has the jurisdiction that the statute gives it. And the jurisdiction is to approve or not modifications to the implied terms. Well, this isn't a modification to the implied terms, it's a modification to the express terms. My lords, on ground two, I come back squarely to the point that there is a constructional point to this extent. My learned friend relies on the drafting of the final paragraph of the obligations as creating a repair obligation in relation to the roof. In my respectful submission, I say that's wrong for two reasons. One, as read, it's doing considerable strain to the wording used there to say that it does extend to an obligation to repair the roof. But the primary reason is this, that where the roof has been explicitly excluded under clause 5, that is, I think it's paragraph 23 in on written, where Lord Neuberger says you shouldn't use later words words later to undermine the clear wording of the clause. And if Arnold and Britton creates as it were, a shift in the constructional landscape, what it really does is it is give primacy to the clear wording of clauses, unless they are really serious, unless there's a serious and genuine conflict with a later clause. But there isn't, in my respectful submission here. Insofar as there is any lack of clarity. It's in the later clause, and one would take the exclusion of the roof in clause 5 as it were, a steer if one needed it. So I say, one, as a matter of straight construction, the later clause doesn't include the roof. Two, if there is any question about it, the fact that the roof has been excluded under clause 5 is something that could be taken to clarify that lack of clarity. But I don't, with respect, suggest that there is any lack of clarity, and that clauses can be construed quite happily by themselves and the roof doesn't come into the second one. And my lords, those are my submissions.
No, well, commendably succinct, Mr. Crozier. Yes, Mr. Ward, did you want to reply?
My lords, if I may, just very briefly, if we are to follow my learned friend's submissions to their logical conclusion, what he says is, this lease was drafted, it included a payment obligation and a repair obligation, both of which tracked the statutory provisions. The parties didn't want to impose a payment obligation on the tenant, but wanted to leave a repair obligation on the landlord. So they achieved that by excluding the repair obligation on the landlord, insofar as it was express, and being otherwise silent as to the implied obligation. My lords, I say that is just impossible to accept. I say also the fact that a lease must, according to section 139, conform is relevant. And it's relevant because, again, if we were to follow my learned friend's submission to its logical conclusion, the right to buy lease would occupy the tiniest amount of paper.
Well, they are quite short, these leases.
My lord, indeed they are, but not to quite the extent that perhaps we're being invited to conclude. The point being that the Act sets out in great detail that which must and must not be included. The implication, or the words dealing with implication, are saving provisions. And they are saving provisions where there are things which are absent or have not been dealt with.
Well, I'm not sure that's right. I mean, to take the repairing obligation, which is the one we are concerned with the implied covenants in 14.2,
Yes.
it doesn't say a lease granted under the right to buy shall include a covenant by the landlord to do X. If it had done that, then one would indeed expect any lease granted to include express covenants to that effect. Instead, the drafting technique used is to say there are implied covenants. And we know that those implied covenants can be excluded or modified, but only with the consent of the county court. So it seems to me to be entirely in conformity within the meaning of section 139 to have a lease which says nothing about the landlord's repairing obligations, leaving those entirely to be taken from paragraph 14 as implied. And I don't think you dispute that.
I do not, my lord.
So I don't myself see paragraph 14 as being a sort of belt and braces provision, which I think was how you described it, as a fallback in case the parties haven't done what they should have done, namely put an express covenant in. I think it's entirely possible not to have any express covenants at all, and just rely on the statute.
My lord, it is, absolutely. But what I say is the requirement that the lease complies prescribes or sets out the format that the law is expecting, or the provisions, the matters which the law is expecting to be included. The words of implication, and I limit my submission to the words of implication, are the saving provision. My lord, that is my point. Otherwise, it would be impossible to have a lease that didn't conform as a matter of law.
But there are other express obligations. You know, the term must be at least 125 years. You have to do this and so on, which you do need to actually physically write into your lease.
Yes.
Because you couldn't leave the term to be implied. But this obligation, you can just leave to be implied.
Well, yes, you absolutely can leave it to be implied. Yes, I absolutely accept that.
Yes. Thank you.
My lord, I'm grateful. Well, the other point that I wanted to make was just with reference to my other friend's comparison of sale of goods. And I say that does not take us anywhere here, because it's to miss the point.
You can exclude the sale of goods implied terms by express terms if you want to.
Yes, but the point about this is that this piece of legislation provides a mechanism for that, and it expressly anticipates them. That is my point. We are not silent on something. We haven't got something that is in conflict with the regime, the statutory regime. We have got something which is expressly anticipated by the statutory regime. My lords, that's all I wanted to say in response, unless I can assist with any other point.
No, thank you very much.
Thank you very much.
We'll just rise for a few minutes to take stock of where we're up to.
What else
I have a touch screen one, but I hadn't got used to the touch command sufficiently to risk it. Because I thought if I was going to have to refer to something, I would pick it up and and
So you're one of those.
yeah.
Wow, that's good. This was a very cheap one from Aldi.
So,
80 quid.
well, mine was only for some reason it was discounted on the day I bought. There was a limited number that came as a discount voucher, so I got a touchscreen for 100 quid.
Actually, very low.
Yeah.
That's what I was thinking. Good question. You did the right thing. I totally agree. We've got a horrible situation. I did work for a bloke for some years and he keeps not paying. I promise I'll pay you. I'll pay you. Big parcel of land being sold. I'll pay all your bills. Parcel of land gets sold. We paid all our bills. He's screaming, I didn't give you authority from that company to pay those bills. The other company, I'm going to burn your office down. Fortunately, I've got emails from him saying, I'll square my bills on the sale of this. But he's a very volatile bloke. And you have to take that threat serious. Especially if Plymouth stock has been burnt to the ground last night and nobody bothered to tell me.
Yeah.
I mean, fortunately, it's a recorded call.
Yeah.
So I can just flip it over to the police and say, you visit him and tell him to back off.
So,
I always find the signage in the LCJ terrible. You sort of look at a map, oh, it must be that direction. You look in that direction, nothing says. You keep wandering down corridors till eventually it says East Block. But you've walked for ages.
oh, did you come in the front?
Yeah, I come in the front. Yeah.
The Court of Appeal entrance.
Well, I know, but I came from Temple.
Ah, yeah.
So.
You see, from Middle Temple Lane, my rookie error was that I didn't divert round by Pret-a-Manger,
Oh, yes.
because it was literally straight across the road and straight up. Because it's Belliard's the continuation of Middle Temple Lane.
I know, I got it wrong here. We got them circle.
Your two new barristers. Very good, you know.
Yeah, I know.
I mean, they really are.
Well, Tim Walsh phoned up me and Denny Matthews to say that Sam, my people,
Yes.
it was the best. It was the best multi-track advocacy from a pupil we'd ever seen.
It's fantastic, isn't it?
Yeah.
Give you a shot. Thank you. Sorry for our rather piecemeal arrival on the bench. I'm afraid there are some stairs outside which are slow going for me at the moment. Thank you both very much for the submissions you've made to us this morning. We're intending to give judgment orally this afternoon. So for that purpose we're going to rise now until 3 p.m. We'll resume then. It's all right, never bring it on. Thank you. 3 p.m.